Hearing in the matter of George C. Cannell.
Mr. Price.
May it please the Court. In this appeal, I appear with Jonathan Price for the appellants, and my learned friends William Bennett, King's Counsel, and Godwin Basutil appear for the respondent. I'm proposing to make my submissions by subject matter following the structure in the appellant's case. But I'm conscious that my role is to assist, and of course I'm very happy to address any issue at any time to the convenience of the Court.
If you proceed on according to your plan, I'm sure I or my colleagues will interrupt you if we wish to change it. Thank you very much.
I'm most grateful for that indication. This appeal relates to the interpretation of Section 3 of the Defamation Act 1952 and the availability of damages for distress absent financial loss. It raises a number of important and interesting principles of general importance. However, whatever legal route is taken, the outcome on liability depends on the admissibility of three primary facts found by the judge which demonstrate that no loss was caused by the two publications complained of and that none was likely to be caused at the date of publication. In relation to the latter, that none was likely to be caused at the date of publication, I accept that the judge didn't make this specific finding, but the issue was raised squarely in the respondent's notice on behalf of my client in the Court of Appeal, and it follows inevitably from the three primary facts found by the judge that there was no likelihood of financial loss as at the date of publication. I don't actually think that is challenged by the respondent in this appeal. So it's the admissibility of these three facts, whether the test is historic or forward-looking, that is at the heart of the appeal on liability. And my overriding submission is that whichever way you look at it, there is no justification for the exclusion of these three facts, or indeed any fact negativing the likelihood of financial loss. There's no justification in the wording of Section 3, the nature of the tort, relatedly legal principle and coherency, none to be found in the authorities preceding and following the 1952 Act, and certainly not in the Article 10 jurisprudence. Because of the centrality of these three primary facts, I hope I can be forgiven if I restate them briefly and how they directly relate to the likelihood of financial loss arising from the falsehoods complained of. There are, of course, two publications complained of: the telephone call to Butler, a client of the second appellant, from whom the respondent was seeking business, and the email to Lingerfelder, the respondent's line manager.
Sorry, can I just, when you've been telling us about three primary facts, yes. I understand two primary facts: no loss was caused ultimately, and none was likely to be caused at the time of publication. What's the third?
Those aren't the two primary facts. Perhaps I could just state them. That'd be helpful. The first is that Butler had firmly decided never to instruct the respondent as a result of an unfortunate previous interaction, to use his words, as recorded in the judge's judgment. He found her to be a nightmare from the start, so he conclusively decided not to do business with her. The other two facts relate to Lingenfelder, and they both independently and conclusively negative the case on loss likely or likely as at publication or likely to have happened as at the date of trial. The first of these facts, which isn't mentioned actually in the respondent's case, notwithstanding the length of the consideration of the facts, is that Lingenfelder did not want the respondent to deal with the second appellant's clients and had warned her against doing so at the start of her employment, and that this was not due to any contractual restriction. It's a very important primary fact, and that's, I can take you to judgment if you wish. It's 92 and 93 on page 198, and then he comes back to it in his conclusion as to why the publication to Lingenfelder didn't cause any financial loss at 196. So that's the second of the primary facts. It's the first one in relation to Lingenfelder. And the third primary fact in relation to Lingenfelder, again, independently negating likelihood of loss, is at the time of publication to Lingenfelder, the respondent was on her way to see him with the employment contract, which demonstrated that there were no post-employment restrictions. So that if you freeze the frame at the moment that Lingenfelder reads the email, which is the date of publication when the tortious act, if it is a tortious act, is committed, because it's this reading by the publishee, at that moment, the respondent's on her way to see him with the employment contract, because just before that, she's received an email from my client called the George email saying...
What on earth would be the point of a test that you artificially look at the moment of publication, ignore what happens afterwards, but equally is not a test where you just look at the nature of the words and what is intrinsically likely? I mean, your sort of intermediate possibility seems an absurd test for the law to apply.
Likely as at the date of publication?
Yes. If you look at all the facts at the date of publication, but just shut out what happens afterwards.
Well, yes.
So you have the full factual inquiry, but on a totally artificial basis.
Yeah, why gaze at the crystal ball when you can read from the open book?
Exactly.
Well, that's my primary submission in favour.
Well, then why are you making that argument? I mean, it's your case, this. No, it's not the other side's case.
I suppose I'm making the argument because it's said that the wording of the statute is forward-looking.
Well, it obviously is forward-looking, I would have thought.
And also because that's been the approach in the Court of Appeal in Tesla, which is was the leading authority on Section 3, where the preceding facts were the numerous broadcasts of the Top Gear review, which are clearly relevant. It seems to me that as between a forward-looking test that takes into account all probative facts as at the date of publication, a forward-looking test that essentially just looks at the tendency of the words, surely it's better to have one that has a more realistic view as the likelihood of publication. But yes, I mean, I totally accept this should be a historic test, whichever route one gets to it, because it's simply idle to speculate what would have happened beforehand. And this case is actually quite straightforward on its facts, but one can imagine very complicated cases with a whole series of competing causation factors to publication going on for some time, where the judge has got to sit at trial and go, well, what would have happened beforehand? Well, why do that? I mean, the purpose of the tort is to compensate for loss, and it's assessed at trial, and the damages are assessed on a historic basis. So it seems to be, frankly, crazy to do anything other than apply the historic test, and that was the instinct of the judge. It would be absurd if, on a tendency basis, you said it was likely to cause, and then you actually knew that it hadn't, then there should be liability. But
So do I understand because I think it was left a little bit unclear, at least to me, as to what your principal arguments were. As I understand it, you are saying that your primary argument is that the court should apply what you're calling the historic test.
Yeah, that is preferable, yes.
Assessed at the date of trial.
Yes, that's the best outcome in my submission, yes.
So you say if the words are calculated to cause means if the words have in fact caused.
Yes.
That's just contrary to the plain language of the statute.
Or I have some other options, if I may.
All right.
Well, if I can just continue. So
yeah.
If that's your primary argument, you've then got, I think, maybe two fallback positions. You've so far talked to us about the forward-looking test viewed as at the date of publication.
Yes.
The one you described as crazy.
Well, I said it was crazy well, it's more crazy if I'm, sorry, I don't know whether I should just, I would just be clear, forgive me, I'm saying it's crazy to have an inherent tendency test. It's certainly preferable to have a test that takes into account the reality of likely loss as at the date of publication. It's a tendency test that's crazy. It's preferable to have a historic test, but a forward-looking test from the date of publication, if that's what the statute compels the court to do, is preferable because it more realistically addresses the likelihood of loss. I mean, why exclude relevant facts on the likelihood of loss? There's nothing in the statute that compels you to do that. If you feel the statute compels you to apply a forward-looking test, and I'll have my submissions of why it doesn't, I can deal with the wording now or whenever suits, but one has to define clearly what it is that's necessary in order to satisfy Section 3, and my submission is it's much better to have a forward-looking test that takes into account everything, that takes into account a very limited and artificial range of facts, which has any resemblance to the likelihood of loss. In practice, you can see the case law, that's not how the case law has been, and there's nothing in the statute that requires that. But
and is there then a second fallback position, which is this presumption?
yes.
Right, you've not mentioned that so far. I wondered if you could...
Of course, yes.
Yep.
I was thinking, well, the court might struggle with the forward-looking nature of the wording in the statute, which I've accepted. And the answer to that is that all the statute on its face does is to remove the need to allege and prove special damage. And since you only have to allege what you need to prove, you can just get rid of allege and say you don't need to prove special damage. And it is perfectly tenable as a matter of principle and coherency just to view Section 3.1 as giving rise to a rebuttable presumption, which would then enable the court at trial on a historic basis to reject the malicious falsehood claim on damages ground if it's clear that no financial loss has been caused. So that is a perfectly respectable way as a matter of principle of coming to the historic test if the court thinks that the historic test is the best possible outcome. And of course, this is lawyer's law, where the court should be striving for the best possible outcome. Of course, I've got the Human Rights Act if I need to, and very strong arguments on that in my respectful submission, which would not present a problem with the words are calculated to cause, could easily be read as likely to have caused. That would be well within the grain of the litigation and the wide scope of interpretive powers of this court when Article 10 is engaged, which the case law makes clear that it is engaged. And my submission will be, if it is engaged, it can't permit as proportionate an interpretation, the damage element of malicious falsehood cannot be that you can bring a claim restricting freedom of expression when there is no financial loss demonstrably. You can't justify the interference that claim will give. So just to be very clear on all the jurisprudential routes in, the first is that you construed Section 3 historically without resort to the Human Rights Act. And I understand the point that's been made by my Lord Legate on this. The second is that you construe it historically by taking into account the Human Rights Act, which is perfectly permissible. The third, sorry, I'm going a bit fast here. The third is if you apply a forward-looking test as at the date of publication, which does not exclude probative facts on the likelihood of loss. And the fourth is if you treat Section 3.1 as giving rise to a rebuttable presumption, which on the facts of this case, you'd have to decide whether the rebuttable presumption was satisfied just on the inherent tendency of the words or likelihood of date of trial, but it wouldn't be satisfied on likelihood as at date of publication. The presumption would, if it was a as at publication you took into account all probative facts, the presumption wouldn't even be raised because it wasn't likely. But if it's on the inherent tendency of the words, then it operates in the way that the judge described it. Words that inherently have a tendency to cause financial loss, okay, but if it can be shown that they haven't done, the defendant shows they haven't done, then the claim fails on that basis. And the judge didn't explicitly use the words rebuttable presumption, but his instincts and what he said was consonant with principle, and in my submission, obviously desirable and correct as the best possible outcome for this tort. Because, I mean, the respondent can't point to any reason in terms of principle, justice, practicality, why a malicious falsehood claim should be brought where there's no likelihood of loss in reality at the date of publication and no loss has been caused. So why permit such an outcome unless you're absolutely driven to it, which you clearly are not in my submission.
Does the historical test obliterate the section altogether, because really this leaves the position as if there were no Section 3?
No.
What is the
benefit?
What is the benefit of Section 3 on the historical view?
Yeah. So prior to Section 3, you had a requirement to allege and prove special damage, and we can debate exactly where the boundary is of special damage, but undoubtedly what it didn't permit a claimant to do is to submit that there must have been some financial loss here. That is the inference you draw. I can't actually point to it. I can't come up with a particular figure. But if you take all the circumstances into account, there must have been some financial loss. That was the approach in inducement of contract, and remains the approach in inducement of contract, running parallel with the time when the House of Lords was saying in malicious falsehood, it's got to be special damage, it's got to be certain, it's got to be precise. So what is the benefit? It allows the claimant to say, there's probably been some loss here. And that clearly meets the mischief of Section 3.1. Why do we need to go any further than allowing a claimant to say, in all the circumstances, there's probably been some loss? We don't need to go any further, and we don't need to prevent a defendant from saying, okay, maybe you've got a prima facie case to that effect, but if you look at the facts, there hasn't been any financial loss. I mean, Tesla's quite an instructive case in that respect, because what the Court of Appeal accepted was that if I can just, briefly on Tesla, it was criticisms of a Tesla car, quite serious ones, that it ran out of power, the brakes didn't work. Causing there, obviously, an inherent tendency to cause loss, and also, in fact, in practice, a likelihood of loss, if you put that out on the BBC, to millions of people. So the Court of Appeal said, yeah, you can get your case up and running on Section 3 on the basis that allegations like that are probably going to put some people off buying your car. But the problem is, Tesla, this has been broadcast 100 times outside the limitation period now, before Mr. Musk got upset about it and wanted to do something. And those 100 broadcasts, which were clearly taken into account on causation in relation to Section 3, means that you have no real prospect of establishing likelihood of loss on Section 3, and the claim gets struck out. Of course, one can think of other cases of competing causes. But that is a good example where the inference can get raised by the claimant perfectly properly without any need for special damage, no quantification, just common sense, what would ordinarily follow. But hang on a minute, on the facts of this case, there's clearly no loss. I mean, all these facts would have to be taken into account on damages. There's no question, I think, no issue that on the issue of damages, it's an open, it's anything that's probative on loss as a historic at the date of trial. So why, what good reason is there for not taking into account the fact on liability, but then taking it into account on damages to reduce the damages to a nominal sum. I mean,
Well, it might be said against you that a natural interpretation of what Parliament was doing in that section was removing the need to prove special damage because of the maliciousness that still had to be proved and the other criteria that still need to be satisfied. It was setting up a tort that was now actionable per se.
yeah,
Therefore, once one satisfies those ingredients, the cause of action is made out, and one then moves to what damages may be recoverable. But if you can't prove damages, you're still entitled to nominal damages. If you can't prove any loss, you're still entitled to nominal damages, plus potentially the argument about mental distress damages.
well, if I can break that down, hopefully. The first, my Lord Borough is referring to because it was malicious. And in my submission, you don't cross the compensatory line. Of course, I accept that where there has been loss, then if you've been malicious, you might find yourself ending up paying more than a non-malicious offender in considerations such as remoteness, etc., etc. But there's a clear, hard compensatory principle, rightly so for coherence, that the damage is separate element. The damage is a separate element. It's always been, right from the Victorian cases, that's been emphasised, and the human rights cases, that you've got to keep the trade libel within reasonable bounds, and so the damage element is important. Then you come on to the next issue, was Parliament intending to make it actionable per se? And I will submit, I can do it now if you wish, there's nothing to suggest in the wording of the statute in the context of the common law that was the intention, and it would be fundamentally undesirable. The whole trajectory of the law is to move away from actionable per se, where freedom of speech is engaged. That's the whole purpose of the 2013 Act, because of the disconnect between a sort of actionable per se tendency test and the reality of harm. So, in my submission, the court is not driven to such a conclusion by the Porter report or what was said by Mr. Lever, MP. When one looks at the context and one puts oneself in the position in 2023. And there's a further point, which is this, which my submission assists my client. Inherent tendency, the argument is inherent tendency is actionable per se, yeah? It's different from defamation. It has to be different from defamation because actionable per se and defamation, the test is by reference to the notional right-thinking member of society. And of course, the interest protected there is reputation. So it's entirely abstract. Once the imputation has been communicated to another person, doesn't matter who it is, doesn't matter whether they know the claimant, then that actionability at common law kicks in on the basis of how a right-thinking member of society notionally would view the allegation. There's no requirement to show that any action would have been taken to harm reputation, nothing of the sort. It all kicks in on that basis. But the Court of Appeal had to accept that can't work. Even if you have a tendency test, it can't work for an economic tort and financial loss, because financial loss depends on the circumstances of publication. That was the point that I made in the Court of Appeal about the Respondent's case. The Secretary would be satisfied with just calling out the non-solicitation imputation to a random person. And well, the respondents now say that's not what they were saying, but in any event, the court rejected that. But that would have been good enough for defamation, actionable per se for defamation, just calling out the defamatory allegation to a random person. Context and circumstances of publication only matter in defamation, but possibly if there's an ambiguity in the words. But if the meaning's clear, tort's complete, entitlement to damages at common law, publication to a third party. But Court of Appeal accept that's not going to work. So they accept that even on an actionable per se, you have to take into account the circumstances of publication. And then they come up with this idea of the identity and essential characteristics, which has no basis in any of the defamation or is totally artificial. I mean, even if one takes into account the context and circumstances of publication, surely the fact that Butler was never going to do business with the claimant is a fact you could take into account. Why wouldn't you? What's the logic? What's the basis of doing that? Similarly, that Lingerfelder had told had not wanted the respondent to try to acquire the clients of the second appellant and warned her against doing so, irrespective of any contractual restriction. So even on a tendency test, an actionable per se that may have been contemplated by the Porter Committee, you can't strip away the circumstances of publication. And once you allow in the circumstance of publication, you go beyond the inherent tendency of the words. You're just not dealing with a sort of actionable per se defamation type tort. Inherent, as I say, inherent tendency it's pretty meaningless in my submission, but it's certainly in malicious falsehood, but it can't be stripped from the circumstances. Court of Appeal have accepted that. As a matter of, and make it clear, in defamation, don't have to worry about the circumstances. It's enough if it had a tendency to make a right-thinking member of society think the worse of the claimant, and it's been published to one person who doesn't know the claimant.
So, as I understand that argument, you're saying, well, libel, actionable per se,
yeah,
because reputation is as the essence of it.
Yes.
Here, we're not dealing with that. We're dealing with interference with economic interest, let's say, and that therefore it would be unlikely that an action, a tort actionable per se model would be used in that context.
Yes.
I suppose I then say to you, but it is a possibility. It's a logical possibility.
Well,
let's take breach of contract, which most people would regard as essentially concerned to protect economic interests. It is, of course, actionable per se.
yeah.
So it wouldn't be illogical for Parliament to have taken that model. It may not be what you think is the best model, but I'm not quite sure at the moment. I understand that it will be regarded as an odd thing to do. It's just one model on the table, potentially.
Yeah, if I say that there's a number of answers to that, my respectful submission. May I just make clear, libel is no longer actionable per se. And there's the two, we had the showcase here, my Lord Hodge was on the panel, and...
Talking about common law, yeah.
I'm sorry? Yes, common law, yeah. Secondly, it would go clearly beyond the mischief, which was to allow claims to proceed where there was very serious financial loss, which couldn't be evidenced. I mean, by special damage got in the way of that. Third point is the Human Rights Act, which would require you not to reach that conclusion. Fourth point is, even if it's actionable per se, you still have to, what are the circumstances in which it becomes actionable per se? Because it's not, Court of Appeal are not saying communication of the words to anybody, as in defamation. They are saying that the circumstances of publication are relevant. So then the next question you have to ask is, well, what are the relevant circumstances and what's the test as to whether it's actionable per se. The fifth point, I think, is that one is dealing with lawyer's law. So this court, even if the interpretation or the approach of Parliament in 1952 was not illogical, which is quite a low bar. If this is not the best approach in 2023, well, what's stopping you from interpreting it in the best possible way? And that's and I think the next point is that the authorities, pre and post the Act, have not proceeded on the basis that it's actionable per se. It proceeded on the basis that there is some meaningful inquiry as to likelihood of loss, either from a historic viewpoint or as at the date of publication, taking into account all relevant circumstances, not just an inherent tendency test. So the court would be just going back to 1952, going back to or in fact, just not even 1952, just a tendency test in defamation, which is effectively been discredited and superseded and subject to much criticism. And we're putting the law in a totally different direction to the way that it has been proceeding thus far. Nobody has ever submitted, prior to this case, that Section 3 is satisfied with an inherent tendency without any meaningful assessment of likelihood of loss in practice. I hope I've covered everything to address that point. I think I was on my third primary fact, if I may, which is that, yes, sorry, my third primary fact was, I did get that was that the respondent was on her way to see Lingenfelder with her contract. It showed there was no restriction. And then this is a case where what was likely to happen as at the time of publication did in fact happen, because a few minutes after publication, Lingenfelder saw the contract, accepted that there was no restrictions, 100% behind the claim. And just the way those facts fit in to the loss relied on is as follows. The imputation complained of is the existence of breach of a non-solicitation clause. The argument in relation to Butler is when he's told that he goes, oh my gosh, I shouldn't be instructing this person who I want to instruct because there's a restriction I could get done for whatever, I'm just not going to do it. He says no. And then in relation to Lingenfelder, what he does is says, oh, I better not, I better tell her not to try and solicit clients because I could be done for inducing a breach of contract, and it was all wrong. So it just falls down. The notional loss for the tendency test just completely falls down on the facts because Butler had no intention of dealing with the respondent, and Lingenfelder didn't want her anyway to deal with the clients, and anyway knew that the allegation was false. And the other artificial element of the tendency test, or inherently likelihood, it amounts to the same thing, I'm going to call it the tendency test, is that it looks at it in the abstract, not in practice. It doesn't actually follow through. It's not a forward-looking test, so it can't accommodate the possibility of Butler, if he wanted to do business with the respondent, asking to see her contract, or Lingenfelder, if he wanted to make money potentially from the respondent targeting the clients of the second appellant, please can I have a look at your contract to see whether this allegation is true or false. And cases have failed on that basis on a forward-looking test because they take into account the likely reaction of the publishee on the circumstances and the likelihood of verification prior to action. And the common law tendency test just can't accommodate that. It can't accommodate competing causes. There are so many illustrations from the cases about how this just fails in practice, which I'm going to come on to. Just finally, on the judge's judgment, it does contain a detailed account of the relationship between the parties, reflecting the numerous issues raised at trial. But this appeal relates solely to the damage element of malicious falsehood, and on liability, in my submission, it turns on the admissibility of those three primary facts. Of course, I accept that we would not be considering this at all if the judge had not found that my clients had published falsehoods maliciously. However, as the judge recognised, the outcome of litigation does not turn on a moral accounting. And if it did in this case, the accounting that emerges from reading the entire judgment is far more balanced and nuanced than the mere finding of malice against my client. But the more fundamental point is that we're here because this court considers that the damage element of a malicious falsehood claim involves points of law of general public importance. It's important that the law proceeds in a coherent and principled manner, and the outcome of this appeal will impact on all those who publish critical information, whether maliciously or otherwise, and the allocation of court resources to civil litigation involving speech. I was going to go to the rival interpretations, but I think I've covered that. Perhaps other than to say that what I describe as the forward-looking test, which is from data publication taking into account all relevant facts, is conceptually distinct from the historic test. And the Court of Appeal described it as a refinement of the historic test based on after-acquired knowledge. Well, first of all, it's not a refinement because it's viewing it from the data publication. Secondly, since everyone agrees that the test is objective, it doesn't matter when the knowledge was acquired, and presumably the court was referring to the knowledge of the appellant, first appellant. So it's conceptually discrete, and I hope I've made that clear. And I've described the inherently likely test as a tendency test because there's no difference. The ratio of Court of Appeal was that such an allegation has a natural tendency to cause financial loss to someone whose income is commission-based. The necessary harmful tendency was established, that's paragraph 72. 14 references to the tendency in the judgment of Lord Justice Warby. And the inherent likelihood is, again, just back to the words, excluding other facts. So I've explained how the rebuttable presumption would work. The fact that it's evident that the statute only dispenses with the need to prove special damage. I hope I've illustrated the gap between inferring that financial loss has taken place and proving special damage. So I was going to...
And that argument was not put forward below, so this is a new argument that we're looking at de bene esse, as I understand it.
Well, the argument that the historic test had something to... It was an advantage for the claimant. The point put by my Lord Legate was very much below. That said there was a distinction between special damage and inferring financial loss. And I gave as an illustration what was said by Lord Justice Moore-Bick in Tesla, perhaps. Well, I mean, you know the argument, but in answer to the specific question, that was definitely put. It was also definitely part of the Appellants case in the Court of Appeal, that once the inference has been raised, it's open to it being rebutted by the defendant. And that's what happened in Tesla. And that was put forward within the confines of Section 3, the ability to rebut. And what struck me, I'm afraid belatedly, as I was preparing, was that another route to that is by limiting the ambit of Section 3 to give rise to a rebuttable presumption. So it doesn't actually define the damage element, it gives rise to a rebuttable presumption, and that's the reason for the note. So that wasn't explicitly raised below, but what was below was the idea of it, the concept of it was below. I'm just looking at my note in September. It's the judge's judgment at 209. Perhaps I can just read it, because it's not very long. There's another route to this conclusion, he said. So he said that the authority suggests it's a historic test. He says another route to this conclusion is the claimant can satisfy the court that the words were on their own, and therefore in the abstract. What's the reference? 209. 209. Paragraph 2.
Paragraph 209.
Yes, paragraph 209. It's sorry, I should have had this. It's page 220 of the bundle. In fact, would you mind going to page 220 rather than me just reading it out? I think it might be easier. In my submission, the judge's instinct was correct there. Why gaze into the crystal ball when you can read the open book? He didn't formulate, as a matter of legal principle, how that route would run. And what?
Well, that argument seems to have the merit of being reconcilable with the language of the section, because you can read it as saying that, well, in the absence of any evidence to the contrary, the claimant doesn't have to come forward with any proof of special damage. It's enough just to rely on the words. But that doesn't say that the defendant can't prove that, in fact, no loss was suffered.
Yes. Just if I may just quibble, forgive me, with that the claimant can rely on the words. He has to rely on the words in the circumstances in which they were published. That's, the Court of Appeal accepts that. It can't just be the words in the abstract. But yes, how the presumption works entirely, respectfully endorse how my Lord Legate puts it. Yeah, so this is entirely coherent, consistent with principle. You see a lot of references in the cases to relieving a claimant from proving actual loss. That's a reference to special damage. You need to prove actual loss. It's a different thing from inferring that some loss has happened, and the court trial will do its best to put a figure on it, even though it's unquantifiable, in accordance with general practice in civil litigation, where you can't put a definite figure on something, and just general damages generally in tort. So, coming back to the question by my Lord Burrows, I did rely in the Court of Appeal on paragraph 209 from the judge's judgment within the historic test, and Court of Appeal rejected that, said that it wasn't paradoxical and absurd to impose liability where the defendant had proved no financial loss had been caused. So all that's happened is that it's been formalised within the structure of a rebuttable presumption.
So where did the Court of Appeal reject that?
At 65. That's on page 170.
It's towards the end of the paragraph, the last sort of 6 lines or so.
Yeah. I think I need to be open with the court that what made me think about this was when I looked at the Scottish Act.
Section 14.
That seemed to me to be the structure. I'm no expert. I was wary of raising it in front of my Lord Hodge, because I'm certainly no expert on Scottish law, but that seemed to me to be the structure. Because...
Have we got that?
Yes, we have got that.
It's electronic 247.
I'm grateful. I've got it... I'm slightly worried by that. I've got it 528. Makes me think I've got a different bundle, which was causing...
528.
So this is...
I think what Lord Hodge was referring to was Section 14.
Yes, it's also...
1952 Act.
Oh, yes, that was abolished. There's a new act in Scotland.
Yes.
Yes, which is...
Yeah, but if you're trying to understand if you're trying to understand what the policy was in the 1952 Act, it seems to me relevant to see what the wording was in relation to Scotland as well as England and Wales.
Yeah, well, we could go to that. Oh, yes, so that's...
You're wanting to refer us to the more recent Act, yes?
No, let's start there. My understanding, forgive me if I'm wrong, is that the law was treated as basically the same in Scotland, and this Act was specifically on the damage element, on Section 3, was simply replicating what the law was already, what Section 3 Act, the effect of Section 3. But it's true to say that Section 14 applied Section 3 to Scotland. That's from the 1952 Act,
yes,
which we can go to, and then that this Act has codified torts relating to malicious publication. And this is the Defamation and Malicious Publication Scotland Bill.
You say that is a codification.
That's my understanding, it's a codification. But
how do we use a later codification as an aid to interpreting an act many years before?
Well, it may be unhelpful. I mean, it was where the idea came to me.
Yes, okay. Which you've produced the bill as passed.
Yeah. So it's paragraph 20, section 21 is the start.
What's the page number?
It's 533.
573.
533.
Sorry. Yes.
What's interesting here is, first of all,
I'm sorry.
Yes.
You said that it was a codification.
Yes.
But the title to the bill, this is an act of the Scottish Parliament.
Yes.
It's to amend the law of defamation, replace the common law delicts of verbal injury with delicts of malicious publication. So it doesn't look as if it's not described as a codification. So it's not like the Sale of Goods Act.
It wasn't codifying defamation. It was putting in a serious harm requirement similar to the one in the 2013 Act here.
How does that assist us in construing and deciding the effect of the Act passed in 1952?
Well, it may not, but I was open with the court. I mean, there is this statute in Scotland which purports to put Section 3, put the whole damage element on a statutory basis, and also deals with injury to feelings, provided there has been some financial loss, specifically deals with that. So I thought it may be of interest. But I mean, I don't need to go to it. My primary submission is that the rebuttal presumption works.
Just before we leave that, can you just clarify your thinking as to why this helps why it clarified for you, if you want to put it that way,
yes,
that there might be a presumption that was rebuttable? Where are you looking at?
I'm looking at the damage element it starts in 20, yes, the damage element in 21(1)(b), which is the same damage element for each of the malicious publication torts. And it's the statement has caused or is likely to cause.
But that's just a straightforward proof of causation of loss. There's no presumption element at all in this.
No, but then there's a 24
Okay.
is a limit on the requirement to show financial loss, which I understand to mean prove financial loss. You don't have to prove financial loss if the statement complained of is more likely than not to cause such loss. And I emphasise, it's not has a tendency to or even calculated to, it's more likely than not. So that seems to be allowing for, instead of proof, an inference, but it's got to be directed to the key element of the damage of the tort in 21(1)(b), which is that it has caused or is likely to cause, and that always likely to cause is clearly looking forward from the date of trial, and that way it mirrors the serious harm requirements in defamation as a court, this court in the show conclusively held that where it has caused or is likely to cause, you're looking forward from the date of trial, you're not looking forward from the date of publication. So I readily accept that if there's a possibility or a likelihood that as at the date of trial loss is going to be caused in the future, well, that would be sufficient. It would be very unusual if no loss had been caused before trial, but it's a possibility and consistent with principle and the compensatory purpose. But the key element there is the statement has caused financial loss. That's the element of the tort. But you can prove it by, you don't have to show it, prove it, if it's likely to. By specifically defining the requirement that the statement has caused financial loss, it made me think that still remains, as a way of just explaining how it remains the gist of the tort.
In applying section 24, the time at which the judgment is made whether it is more likely than not to cause such loss is the trial. Is that right?
In 20...
Section 24 of the Scottish Act.
Well, it could, yes, it could be the date.
I don't know.
I mean, I would have thought it could be the date of publication as well. But maybe not, I don't know. But it just... We don't have to actually, thankfully, we don't have to interpret this statute.
Is this act, is this the consequence of a Scottish Law Commission report?
I think it may be, yes.
Yes. Well, if you're going to rely on this act as an aid to construction of an act 2 generations before, then I think we better see what the Scottish Law Commission thought of the matter, but we can come back to that.
I don't rely on it. I'm just being candid. That's what made me think about it in those terms. And
does the Scottish part of the 52 Act give any assistance? Do the Scottish provisions of the section of the 1952 Act give any assistance?
No, I mean we can go to them. That's there in.
It was that I referred you to earlier. It's page 247.
It's basically just the same as the English, so it's the same question arises.
Yeah.
I just mentioned also that the Scottish Act does have an ability to recover for damages for distress, but the explanatory notes make clear that's only when there has been financial loss caused.
This is the new Act.
The new Scottish Act, yes.
Yes.
Only when financial loss has been caused can you get distress. That's made clear in the explanatory notes. Obviously, I'm jumping subject matter, so I'm just dealing with liability at the moment.
Yes, if you look at the Scottish provision in section 14, it says that the pursuer, the equivalent of the claimant, doesn't have to aver or prove special damage. Yeah. So you say that is not inconsistent with a presumption?
Well, yes.
Yes. Against you, it said that there's a completed cause of action and nominal damages follows.
Yes, well, that was the point made by my Lord Burrows, and hopefully I've given all the reasons in opposition to that. And of course, even if they would still have to, you still have to look at the circumstances of publication, even if it was an automatic remedy.
Am I to take it that there's nothing that you're founding on in the Porter report which casts light on this? Because I would have thought the correct approach is to look to see what the mischief was and what the report recommended when construing the provision. But are you saying there's nothing that casts light on this point?
It's not directly on this point about the admissibility of competing causes.
No.
And it's also, I have to say, a little strange to say there's a problem with publications causing very serious financial loss, which the rules of evidence prevent as demonstrating as financial loss. I mean, why does the evidence prevent that? And we've certainly moved on from 1952 in terms of our accountancy skills, our litigation skills, the availability of documentation to specifically prove financial. Sorry.
Can I just, I mean, we've mentioned the Porter report. The relevant part is on page 474. And it does look as if the Porter Committee identified the mischief in paragraph 51.
Yeah, 474.
And in paragraph 51, they refer to the necessity of furnishing proof of special damage, the technical rules of evidence, and then they say, in the result, the injured person is left without any remedy for the loss which he has suffered.
Yes.
In our view, this constitutes an injustice which should be righted by an amendment of the existing law.
Yes.
That's helpful to you, isn't it?
Yes.
Right.
Well, that's what
you might have been taking us to it then.
I was coming.
Why are we looking at Scottish provisions later on and later case law? Don't we start by looking at the Porter report and work from there?
We start with the preceding common law with respect, then we come to the Porter report. The Porter report has to be seen in the context of the existing common law. But
Yes.
if I just may observe on this particular, I mean, it's quite clear. The aim is to give the claimant a remedy when there's an inability to prove special damage, but loss has clearly been suffered. And that's solved by the historic test, whether it's applied directly or by a rebuttable presumption, which you allow finding on liability where it's likely there's some financial loss has been caused, which can be based on a very high level of inference, but in an appropriate case where there's more specific facts to rebut it, no reason why the defendant shouldn't rely on it to show there was no loss. But it's quite strange to think that you could have publications causing very serious damage, which owing to the technical rules of evidence is impossible to prove strictly special damage, as I say. But that also begs the question of how do you know that it's caused very serious damage? Well, the answer would have to be it's an obvious inference from the circumstances. That's the only, if there's no evidence of it, then...
Well, you can imagine, can't you, an advertisement, as you gave the example of Tesla on the television or something, but there isn't any previous history as there was in that case, and it's just you can draw a natural inference that saying false things about somebody's goods is going to result in people not buying them, but you might not have any evidence to show that anybody actually chose not to buy a car as a result of seeing the advertisement.
And this is particularly appropriate where it's a publication to the public. It's also...
That wouldn't, in theory, you'd say, stop the defendant coming forward to find everybody who'd actually heard the advertisement broadcast and saying that actually they were never going to buy a Tesla anyway.
Well, that would be a brave defendant.
Yes, but I'm just talking about the principle of it.
Yes. I mean, I think as a defendant, you'd have to look for something more fundamental than that. For example, what existed in Tesla. And we were going to look at Tinkler, which was another one where there was competing causes, much more likely to cause a loss both before and after publication. And it commonly arises that there are big causation problems which just can't be accommodated on a tendency test.
What do you say the technical rules of evidence were that are being referred to here?
I don't really know. I mean, in Radcliffe and Evans, we come on to, the court did say there was evidence of a decline in business. So maybe show it was like this, and then it went like that, and there was no other cause. And references in case law post 1952, which talk about the no need to evidence loss, are seen within the context of special damage. But I don't know exactly what rule it may be. I mean, there's certainly a rule that it's got to be reasonable and certain, and that comes with that is that, in my submission, it's got to be quantifiable. That was the understanding of Lord Justice Morbick in Tesla, which my submission was correct. But in my respectful submission, we don't need to be too troubled about where exactly the boundary between special damage and general damage existed, and exactly how much of a fetter the rules that were pertaining to special damage restricted people from claiming loss when it was likely to have occurred, because I accept that a claimant should be entitled to draw the inference that loss has happened without, that's clearly what the statute was intending to bring about, and that's a benefit to a claimant, and it's obviously just and right that a claimant who's likely to have suffered financial loss as a result of a false and malicious imputation should be able to recover for it. And law doesn't need to really go any further than that, in my submission. Certainly not to a situation where, in very many cases, there'll be liability when it's clear there's no loss. Before I come to the common law cases, which I was going to go to the common law cases before, so the cases before the Act, and then the cases after the Act. But before I do that, I'd like to just make some general submissions, if I may, about the nature of this tort, which in my submission are relevant to the task that the court is undertaking, and the conclusion that financial loss, or the probability of some loss, remains the gist of the tort. So there are four relevant features of the tort of malicious falsehood in my submission. Firstly, it's an economic tort. Secondly, it directly engages with Article 10. Thirdly, it's very widely framed. Fourthly, it's quintessentially lawyer's law.
I'm not quite sure what lawyer's law means. Keep using that phrase.
It's a phrase that my Lord Burroughs has used to, maybe I have a slight head start on this one, to describe, it can be contrasted with laws which involve controversial social policy choices. So, when a lawyer's law is nuts and bolts of the law, legal coherence, there's no particular social policy factors involved. It's just we want to get the best possible law that works within a structure. And my Lord Burroughs has suggested extrajudicially that when you're interpreting what's called lawyer's law, you should be more willing to strive for the best possible outcome as at today's date, rather than leaving it for Parliament. If it's involving a controversial social choice, you think it's maybe not the best one, but you think, oh, maybe we shouldn't be interfering with the Supreme Court. My respectful submission is with lawyer's law, you have the duty to come up with the best solution that works within a statutory framework. That was my fourth element of the law. If I can go back to the first, which is the nature of an economic tort. Of course, I readily accept that the elements of the economic torts necessarily vary. The relevant commonality for the purposes of this case is that the interest that is recognised for protection in an economic tort is economic, nothing else. The harm that the torts exist to provide compensation for is financial loss, and one shouldn't lose sight of this basic compensatory principle, which is perhaps best stated by Lord Hope in Revenue and Commissioners' Total Network, which is a decision of this court involving unlawful conspiracy. It's in the supplemental bundle. It was in the original bundle, but only as an extract, and this particular part of it wasn't in the extract. So it's been put into the supplemental bundle on page 205. If the court wants me to just give a brief resume of the facts, I can. It was claimed by the revenue for unlawful means conspiracy, and the main issue was whether this was a claim that was open to the revenue. And the conclusion was that it was. The respondent relies on statements by Lord Neuberger emphasising that these torts have different elements, and readily accept that. But the underlying interest is economic, that's common to all, and one can see that paragraph 26 of Lord Hope. Starting at H, the function of an action for damages. If I could just ask you to read that until the end of the paragraph. It's page 205 at the bottom, paragraph 26 at H, just above H.
Oh, yes.
This is all axiomatic, but perhaps it's just worth seeing in black and white. There's reference there to Tony Weir, a case on tort, in that the significance of economic interest is played down compared with other interests which the law seeks to protect. He who steals my purse, steals trash, etc. It's less valuable than reputation. But I accept that economic loss is, of course, properly recoverable, and that's the purpose of Section 3. So I don't think I'm going to start debating whether it's more or less important than any other interest. But it's clearly the economic interest which is protected by the tort, and then under ordinary principles there has to be some loss to justify the initiation of proceedings. Another aspect of the basic compensatory principle relevant to this case is that the law doesn't compensate people for being exposed to a risk of injury, generally. Tendency test is sort of based on a notional risk of injury, but that's the law doesn't really compensate for that. And an example given by my Lord Leggett in another case, which isn't in the bundle, but it's just all axiomatic. If a man drives at high speed the wrong way around a roundabout, putting the lives and safety of others at risk, by good fortune he avoids an accident, he may be prosecuted, punished for dangerous driving, but the people whose safety is engendered cannot claim damages for having been exposed to a risk of an injury. If the law were to recognise any such principle of compensation for exposure to risk, it's difficult to see where it would ever end. These are obviously sound principles.
Have you got a reference for that quote?
Marathon, Asset Management, and Seddon, 2017, IRLR 503, which I came across belatedly being a defamation lawyer. I mean, it's a commercial case. I can provide copies of, I've got copies here, if the court...
Well, if you're founding on a passage, I think we should see the judgment.
The other side, yeah? Amen. Case involved employees taking confidential documents, but not benefiting from them, and the end result was nominal damages because of the property rights in the documents. The basic compensatory principle is noted, paragraph 154. The submission is made by the claimant, well, we weren't injured, but there was a risk that we could have been injured by what they did. And that was described as threadbare by my lord at 162. And that's the example that I've just cited. At 164. My lord refers to the principles that may assist a claimant who's got difficulty in proving loss, including presumptions that may be made. Then at 214 there's a restatement of the compensatory principle, which makes clear that even if you take advantage of these principles as a claimant, if you still don't end up with any loss, that is tough. You don't have a remedy. And then at 249 to 252, there is set out the obvious benefits of a historic test from the date of trial rather than a forward-looking test from an earlier date. Will obviously be far more complicated where there are a number of factors relevant to causation to have a forward-looking test from an earlier date. The second, shall I pause? Shall I the second relevant feature of the tort is the direct engagement in the exercise of freedom of expression as a restriction. In applying the proportionality test to any element of the tort, including Section 3, and the court is bound to apply the proportionality test, it's necessary to consider the availability of other causes of action that provide a remedy for false speech. The most obvious are defamation, data protection. Both provide the possibility of compensation for financial loss, even though it's not the interest that's primarily sought to be protected by those torts. Defamation is reputation, data protection is privacy. Falsity and malice may also be relevant to harassment and misuse of private information. I'm going to come on this afternoon to make my submissions on Article 10. I just wanted to make clear that's a relevant feature of this tort. The third relevant feature is the potential breadth of its application. It potentially covers any false statement on any subject, and there is no restriction on the nature of the financial loss that can be relied on. For example, a number of cases in the authorities' volumes involve political speech, which is generally accorded the highest protection under Article 10. A case called Quinton and Pierce, which I'll come on to, but it involves statements made to voters during a council election where the stated loss was an allowance as a councillor if the claimant was not re-elected, and that was treated as permissible financial loss for the purposes of the tort. Any criticism of a product, that would include a book review, as was the case in Thornton and Telegraph, which is the case we'll look on, or any artistic creation or service made to any person, could be a single person who's a potential customer, could be said to have a tendency to cause financial loss by deterring that person from purchasing. One of the defining features of the modern era is the huge increase in available information in permanent form and the potential for ordinary people to publish in a manner generally or widely accessible that could not have been contemplated at the time of the late Victorian cases formulating this tort or the 1952 Act. Now, a very obvious consequence is that you have a huge pool of defendants and scope for an increasing disconnect between a harm hurdle which is merely directed to the tendency of the words and one rooted in the likelihood of financial loss in reality. The need to prove falsity is hardly a limitation because people make or repeat false statements all the time, and in this talk we have an absence of a single meaning rule which you have in defamation. So falsity, the case on falsity can bite on any imputation that the words are capable of bearing. I'll address the requirement to prove malice in more detail in my submissions on Article 10 because that's relied against me on Article 10 that we've got a malicious defendant. But for the moment, I simply observe that all is required is a probable indifference to truth. There's no requirement to establish that a motive to cause harm was present. So that can be compared with other economic torts in that respect. But where a motive to cause harm is present, where that is a dominant motive, even a belief in the truth will not prevent a finding of malice. It's not very difficult to get a case up and running that an imputation is false and was published maliciously. So the damage hurdle is an important control mechanism given the breadth of the tort. And that's where the intervenor submissions come in, that category, the effect of giving such a wide remedy. And one can also see in commercial cases, this malicious falsehood seems to get lobbed in as a counterclaim quite often, perhaps for tactical purposes, giving rise to a whole further inquiry in an already expensive and complicated case. Well, why do that if there's no benefit? I will deal with those points within the Article 10 primarily from the standpoint of free speech, not I mean, commercial cases, that's just a civil litigation issue, allocation of resource issue, but that is one, in my submission, the court should take into account when deciding what the best outcome is here, whether it's the best outcome to allow all these things to be actionable on a tendency basis. And then the fourth point was lawyer's law, which I've dealt with. So I need to come on to the common law prior to the Act. My overriding submission is that there was a distinction between malicious falsehood and other economic torts, such as inducement and breach of contract, in that the courts are very strict with malicious falsehood, partly because they didn't want to open the doors to endless litigation, to require proof of special damage, whereas in inducement and breach of contract, which is a far more specific tort than just publishing any false statement, the court allowed the inference of financial loss to be made where it was obvious, even if you couldn't point to any specific quantifiable loss. If we can start with Radcliffe and Evans, that is in the authorities bundle at sorry, forgive me a second. Starts at 323.
Is it going to be one of your submissions that malicious falsehood should be treated like inducement of breach of contract?
Yes.
You're saying that in that area, one can use an inference of loss.
Yes.
But you don't need to prove special damage.
Yes.
And that it's that sort of model that maybe one can interpret the words as as importing into malicious falsehood.
Yes, either directly or by the route of a rebuttable presumption. The Court of Appeal said that the historic test was no different to Radcliffe and Evans. So when we go through Radcliffe and Evans, I'm going to show that it was very much focused on evidence of loss, and also that calculated was used interchangeably with likely. And I need to do that if I'm in support of my forward-looking test data publication, which takes into account all the circumstances, because clearly there's no suggestion in Radcliffe or in White and Mellon that we'll come to that calculated was in any way limited just to the inherent tendency of the words. If we can start at page 323, you can see in the heading there's reference to special damage. Clearly, this case was grounded in special damage. It just potentially relaxed what was required, but there's no issue that the court was accepting this for special damage, and there was a need to show special damage. In the head note, you can see a reference to reasonably likely to produce. That's not even calculated, that's reasonably likely. It's certainly not a tendency to produce. And then also in the head note, you can see the reference to evidence. Evidence of general loss of business is admissible. So clearly this was a case where the plaintiff did have some evidence of a loss of business. Court, I'm sure, will be familiar with the facts. It's an article in a newspaper in Wales that's alleged that the plaintiff had ceased business. Obvious prospect of financial loss arising from that. May be instructive to look at the submissions on behalf of the plaintiff. 324.
It's worth looking, isn't it, on 324 at what was proved at the trial. That's
Yes, he proved it, yes.
He proved general loss
Yes,
of business.
yes,
But
yes.
he gave no specific evidence of the loss of any particular customers or orders.
But he proved a loss of business. Didn't have to. He didn't. He proved the loss of business. He didn't infer the loss of business. He had evidence of the loss of business. So proving and evidence are part of the same. And you can see that in, and forgive me if I've missed out anything relevant, but I've tried to highlight what I think fairly represents the judgment. Before we get to that, just the submissions on behalf of the plaintiff at the bottom of 325, 3/4 of the way down, F. Marshall for the respondent. The evidence of the plaintiff's general loss of business was admitted. Defendant statements were published, and it was evidence of special damage sufficient to support the action. Defendant statements were published in a newspaper which was widely read in Wales, and the natural consequence would be to prevent persons who were intended to be customers of the plaintiff and read the statements from giving him further orders. So that's the reasonably likely to, which is the other element of the tort. And clearly a relevant factor here is that this is a publication in a newspaper in the area where the plaintiff does business. It's not a publication to one person, which would satisfy the tendency test. Clearly the extent of publication here, which is an extrinsic factor, is relevant to the natural consequence. Then, moving to the judgment of Lord Justice Bowen on behalf of the court, towards the bottom of 527 is the statement of principle as to the element of the tort. It's about 7 lines up from the bottom. An action will lie for written or oral forces, not actionable per se, nor even defamatory, where they are maliciously published, where they are calculated in...
Sorry, which page did you say?
It's
326.
326.
Sorry, I thought you said 7.
I might have said
I think you
527.
gave the
Yes.
reports page number.
Yes, I'll stick to the pages in the bundle from now on.
Thank you.
So it's 8 lines from the bottom. This is where Lord Justice Bowen sets out the elements of the tort, calculated in the ordinary course of things to produce, so not tendency, and where they do produce actual damage, that's actual damage is used as another way of saying special damage. You see that throughout the authorities. And then turning over the page to support actual damage to be shown, the actual significant. For it's an action which only lies in respect of such damage as actually occurred. It was contended before us that in such an action is not enough to allege and prove general loss of business arising from publication. So he was in a position to allege and prove that, since general losses, generals, and not special damages, etc. Then there's a reference to it not always being used with reference to similar subject matter nor in the same context. Reference to the presumption of some damage in certain cases, and then 3/4 of the way down there's a sentence which starts, but where no actual and positive right apart from the damage done has been disturbed, it is the damage done that is a wrong, and the expression special damage, when use of this damage, denotes actual and temporal loss, which has in fact occurred. Such damage is variously called in all authorities express, loss, particular damage, damage in fact, special or particular cause of loss. And Lord Justice Bowen is not, doesn't think it's very helpful, this sort of categorisation. There's a perhaps more strict approach that we'll come on to when we look at the House of Lords decision, but just going through this judgment, there's further references to evidence to show, and this passage on 328, about a third of the way down, is, in my submission, relevant. The sentence starts in an action like the present, and then it moves on to the question, which is evidence to show that a general loss of business has been the direct and natural result admissible in evidence and, if uncontradicted, sufficient to maintain the action. And one can go through this and see numerous references along these lines. Reference to the nature of the acts being relevant, and the admission of evidence of general loss of business. I don't think there's anything else I need to take the court to there. The next relevant judgment is the House of Lords in White and Mellon, which is on page...
The concern of the committee was the effect of this decision.
I think...
What is it? Can you show us in the judgment of the Court of Appeal the mischief of which the Porter Committee's recommendations were aimed?
I think the mischief comes... Well, this was a sort of more relaxed approach. The mischief comes from the subsequent House of Lords decision in Royal Baking, where they say, oh, this is all very interesting, but for centuries we've been insisting on certainty and precision. And that was the understanding that followed for 50 years.
So that's
after
why
that.
Justice Warby said, really, Radcliffe and Evans was effectively misunderstood, or if only it had been applied, there wouldn't have been the need for Section 3, so something along those lines.
Possibly, but there's still a gap, even on Radcliffe and Evans, between inferring loss and having evidence of loss. And it doesn't really matter exactly what Radcliffe is allowing, because there's a subsequent House of Lords decision, and more significantly, a perception, which is a reasonable perception following that House of Lords decision, that you may suffer some loss, but you won't be able to recover it because it can't be shown to be special damage. And it's also relevant to bear in mind that this argument in relation to Radcliffe and Evans was not made by the respondent in the Court of Appeal. The respondent was the appellant in the Court of Appeal, didn't make this submission. So I tried to deal with it as best I could, insofar as it was put to me, by saying, look, there's still a gap between Radcliffe and Evans, and inferring general financial loss. But I didn't have the Royal Baking Company to hand. I didn't have the cases on inducement to breach of contract to hand, which showed clearly a different regime in relation to proof of damage.
Anyway, you say Royal Baking Powder retracts somewhat, do you?
Yeah. We'll come on to that, but may I first just deal with White and Mellon, because Royal Baking also relies on White and Mellon, and White and Mellon is also helpful on the meaning of calculated.
Okay, so where are we going?
So White and Mellon is on page 441. It's a subsequent decision of the House of Lords.
41.
The facts will be familiar. The defendant sold the plaintiff's infant's food and put a sticker on it saying that the defendant's food was more nutritious and helpful than any other. And the plaintiff sought an injunction and was successful in front of the Court of Appeal, but got quite short shrift from the House of Lords. It wasn't just special damage wasn't the only issue here, but it was made quite clear that special damage has to be proved. I rely on this case more for the use of calculated and likely for the same purpose, and no restriction on the concept of calculated in the way that the tendency test would have it restricted. We start with, at the beginning of the judgment of Lord Herschel, on page 444, halfway down, he's recording, but not necessarily agreeing, with the statements of law made in the Court of Appeal. Lord Justice Linley refers to has caused injury or is calculated to injure the claimant. So he's suggesting that calculated to injure the claimant would be enough. And then Lord Justice Lopez says causing such other person damage or likely to cause such other person damage. So calculated, same as likely. And then on page 158, about 8 or 9 lines down.
Which page, sorry?
Sorry, 445, forgive me. Did you remind me to... Sorry, my fault, but I was looking at the top of the page. There's a reference there to likely to result, calculated likely.
How far down the page? I'm so sorry.
No, it's my fault. It's about 9 lines down. It's the end of a sentence. I'm just illustrating here the use of the word likely, same as calculated, because that's the word in the statute. And my point being, there's no reference to tendency. 1936, the tendency test was well established in defamation. So here we've got these cases, common law cases, which Parliament can be taken to be aware of, which are not mentioning a tendency. It's just a general likelihood test. And then we move to the bottom of page 446, the sentence starting, "But my lords," which is 4 lines up from the bottom. That's assuming, what Lord Herschel is doing is assuming that the Court of Appeal have stated the law right. And one of the things is, that, looking at the bottom of the page, is that the disparaging statement has caused injury to or is calculated to injure the plaintiff. Upon that, there is a complete absence of evidence. Rely on that, because why would you need any evidence if it was a tendency test? Simply look at the words, but there's a contemplation here that there's an absence of evidence in relation to calculated, which is repeated at the bottom of that lengthy paragraph, 5 lines from the bottom, with there is an entire absence of evidence the statement complained of either injured or was calculated to injure the plaintiff. If so, then the case was not even brought within the definition of the law which Lord Justice Linley gives. And then the judgment continues with references to the need to prove special damage. Wasn't even alleged in this case, which concludes at 450 at the bottom, paragraph. So you need special damage. It's an essential element of the tort. And if it's not there, then you can't get an injunction either. If I can just pause there to say that on the historic test, you can clearly get a quia timet injunction if there's a likelihood of financial loss if the publication takes place or if it continues. So the historic test doesn't act as a bar to a claimant getting a quia timet injunction in appropriate circumstances. The nature of a quia timet injunction is to look at the likelihood of what would happen if the publication took place. Then on page 451, we see Lord Herschel's concern about opening a very wide door to litigation, which has resonance in the modern era, with its emphasis on the stewardship of court resources, not putting litigants to the cost and hassle of litigation without good reason. The reference to the open a very wide door to litigation is about 13 lines up from the bottom of that page. I accept that it's made within the context of puffing. So that's the falsity element of it, of the tort. But it reflects a more general concern because of the very breadth of this tort compared with the more specific forms of economic torts that are being developed at this time. A recognition that the floodgates recognition, which is repeated on the next page, 452, halfway down, just consider what a door would be opened if this were to be permitted. Okay, consonant with what my Lord Legate said in the Marathon case about where would be the end to it if we allow claims to be brought on the risk of loss without the fact of loss. I don't think there's anything more that I need to derive from this case. So I can move on to the final decision of significance before the 19... Bit of an echo here, I don't know if that's me. The final case of significance before the 1952 Act, which is, we freeze the frame there and we ask what was the common law context that this Act was being incorporated into. So that decision is Royal Baking Powder Company at Wright and Crossley at page 382. The facts were that the claimant had registered two trademarks with the words Royal Baking Powder. The defendant successfully applied to have them expunged and then issued a circular which potentially bore two meanings, one of which was that the plaintiff was not allowed to sell any tin bearing the words Royal Baking Powder. The other was that it wasn't allowed to sell any product which suggested that the Royal Baking Powder was a registered mark. And the short point is that the only loss that could be proved related to the tins which had the words registered on them, and that was unlawful and therefore couldn't be relied on as special damage, but it was sufficiently particularised. And why I rely on this case is for the emphasis on the need to stick to the discipline of certainty, particularity, which is we can see best from the speech of Lord Robertson at page 103.
I thought you were going to use our numbers.
Oh, I keep doing this. They give me 390. And at the top of it cites White and Mellon, and then at the top of the page sets out the gist of the tort, and this is a passage that's been frequently repeated. Gist of the action is special damage done maliciously unless the plaintiff has in fact suffered loss which can be and is specified. He has no cause of action. The fact the defendant has acted maliciously cannot supply the want of special damage, nor can a superfluity of malice eke out the case wanting in special damages. Then he refers to Radcliffe and Evans at line 35 on that page. Perhaps you could just read that paragraph. He talks about it being a very interesting judgment, but cites the statement within the judgment, the necessity of alleging and proving actual temporal loss with certainty and precision. In all cases of this sort has been insisted upon for centuries. And then he observes that there was precise and definite evidence in this case that was produced. And when you read through the facts of it, you can see they had specific losses where people said they wouldn't buy. Problem was that the blow was to the illegal trade. all the other speeches emphasise the need to prove special damage. This particular damage couldn't count as special damage, not because it was lacking particularity, but because the trade was illegal. That's where the law stopped. What was going on in other areas of the law at the same time? I think we can perhaps best see this from the edition of McGregor, which was called...
I mean, are you saying that Radcliffe and Evans is misunderstood?
Well, it's a question of emphasis. I'm not saying it's misunderstood, but I'm saying that...
It refers to the precise and definite evidence which has been produced with the excellent evidence of special damage, certain and precise.
Yes.
So that's what's required, is it?
Well, yes.
I mean, at the common law.
Well,
That's the effect of Radcliffe and Evans, is it?
Well, I think it's just the effect of a large number of cases.
Yeah, well, Radcliffe and Evans is the leading case, really, endorsed, it would appear here, but...
Well, it's just given as an example. In my respect, I wouldn't say it was viewed as the leading case. It was a relaxation, and it allowed evidence of a general loss of business, providing there was evidence of it. But you can see here...
You're saying that the gloss put on it by the House of Lords was that it was emphasising the need for certainty and precision.
So
yes, my Lord makes a point.
That's the point. I mean, it may be wrong to say the House of Lords has misunderstood the Court of Appeal, but nonetheless, that's what it really comes to.
Yes, and we link those statements to what was in the Porter report about publications which cause very serious loss.
That's right.
So you're saying this is what they're concerned about, that you can't succeed unless you show with certainty and precision your loss, and that a more relaxed approach was called for.
Yes. So we can have a look at what was going on elsewhere. If we go to Main and McGregor on page 1837, this was the first edition to come out after the Act, 1961. And the reference to Radcliffe and Evans is on page 1840 of the bundle. You can't see the page because it's obscured, unfortunately, by the photocopying. But it's 946 of the book. Sorry, yes, it's paragraph 946, page 790 of the book. You can see the reference to Radcliffe and Evans, that a general loss of business custom might be alleged and proved without specifying or calling evidence as to loss of particular customers. And then follow that sentence through, and we see, on the other hand... I'm sorry,
I've lost... What were you looking for?
Okay, we're at page 1840 of the bundle.
1840, thank you.
I suppose if you're working electrically, it's not a problem.
There's a reference to Radcliffe and Evans at the top of the page. Yeah.
And there's a recognition that a general loss of business and custom might be alleged and proved without specifying or calling evidence as to loss of particular customers. And then we get on to the next sentence. On the other hand, there appears to be no move by the courts to regard the damages at large and to draw an inference of pecuniary loss without special damage, as has been done in the tort of inducement of breach of contract. That sentence has been in every single edition of McGregor since the 1952 Act. And then the Act is cited, and the present position is therefore this: with statements falling within Section 3, the plaintiff need not allege and prove specific pecuniary loss, as the court will infer the existence of pecuniary loss and the damages will be at large in a similar sense to that in inducement to inducement of breach of contract. And then there's another sentence which has been in every single edition, starts on the next page, a third of the way down.
Have you drawn our attention to what Harvey McGregor says in paragraph 946 on page 790, just above, right at the end of paragraph 946, after he's mentioned the Act? Because isn't that very similar to your submission about presumption?
Well, it's general evidence. It's a reference to evidence of loss. So that goes back to Radcliffe and Evans.
Well, I meant with statements falling within section 3, the plaintiff need not allege and prove specific pecuniary loss, as the court will infer the existence of pecuniary loss. And the damage would be at large in a similar sense to inducement of breach of contract.
Well, so
isn't that helpful for you?
Yes.
Will you be showing us in due course the position in relation to inducement of breach of contract?
I will do. I'm coming straight to it, but I just wanted to refer to a sentence on the next page, if I may. Third of the way down is a reference to section 3. Section 3, by dispensing in these cases with the requirement of allegation and proof of specific pecuniary loss for success in the action, thus impliedly confirms the view that for all injurious falsehoods only pecuniary loss will ground the action. So no longer a need to prove specific pecuniary loss, but still it's the gist of the tort. If one then turns to 18...
Are the passages on the following page relevant? Page 1841 of the bundle.
Yes, I think you were just referring to. You were just referring to about a third of the way down. Yes. Section 3, by dispensing in these cases with the requirement of allegation and proof of specific pecuniary loss for success in the action, confirms the view that for all injurious falsehoods only pecuniary loss will ground the action.
And I'm now going to move to the paragraphs dealing with inducement of breach of contract, which were cited there. I actually don't have the original edition from 61. I have the current edition. I'm pretty sure it's the same, but in any event, you can see the statements of principle that are there. These are cases decided around the turn of the century. But it's paragraph 48005 on page 1863. If I can just ask the court to read up until the end of the citation from Goldsall and Goldman.
This is the current edition.
Is the current? Yes, it's the current edition. But I actually had to get the Law Society to dig out from their storage the.
Well, the point you want to make is what position is in the sort of inducement of breach of contract.
Running in tandem with the Royal Bacon Company case. It's a very much more relaxed approach. Stated clearly in those paragraphs.
Give the page again.
Yes, it's 1863. So this meets head-on the mischief identified in the Porter report. And in my submission, is sufficiently close to the wording of section 3 that it's a perfectly permissible construction, of Section 3 without resort to the Human Rights Act, without resort to a rebuttable presumption, that what Parliament was seeking to do was to allow this form of inference to be drawn in place of proof of special damage. That's what Section 3 requires. That was the purpose of the provision. To bring malicious falsehood in line with inducement of breach of contract in a coherent manner consistent with the basic compensatory principle, and not depriving any claimant of a remedy that that claimant deserved because it was likely they'd suffered some loss. No impediment in the way of recovery for loss if you apply what's said there to malicious falsehood.
Just to be absolutely clear, what is said where that you want us to apply? Which you're talking about paragraph?
Well, it's the inference.
48005, presumably.
Yes,
You're finding
the inference
what Mr. Justice Neville has said,
yes.
it recorded in 48005.
Yeah, so no need for proof of particular damage or even proof of a general loss of business if it must have caused some financial loss. Well, I even wouldn't put it even as high as must. On the balance of probabilities, it's likely that some financial loss has been caused by this publication.
Likely there means must, because it's assumed to be the case if it passes the 50% threshold.
Yes. It's a standard burden of proof, yes, and that would mean must. There's nothing in the wording of Section 3, and I emphasise the wording of Section 3 in the common law context, to suggest that the purpose of this provision was to discard the basic principle that financial loss is the gist of the tort. The most plausible, and indeed the best interpretation, is it permits a malicious falsehood claim to be founded on an inference that financial loss is likely to have been caused and claimed as general damage. Obviously, benefit of this provision will be greater in cases of wider publication. The judge was correct to recognise at paragraph 207 of his judgment on page 220 that when you're dealing with limited publications, you're in a much better position to make findings as to the precise circumstances of publication and the precise likelihood of loss. And receive evidence from the publishees. Greater scope for specific proof that financial loss has or has not occurred. And then I come back to the rebuttable presumption point that I made earlier. Nothing in any of this suggests some sort of bar against a defendant rebutting an inference on particular circumstances. And this happily dovetails with the Article 10 jurisprudence, the need for there to be a threshold of seriousness before speech is restricted. I'll come on to this afternoon. As between the forward-looking and historic tests, what's the preferable option if you're allowed to pick the preferable option? Well, obviously the preferable option is the historic test because you're assessing damages at trial. I think I've probably made these points in answer to questions already. It just all falls within the don't look at the crystal ball point when you can read the open book. And it's in paragraph 31 of my case. I don't think I need to address it any further because I've dealt with it in answer to questions that have been asked of me. Final point on section 3, because this was relied on by the Court of Appeal, is the additional requirement in 3(1)b in relation to oral falsehoods. and that is that the pecuniary damage has to be in respect of any office, profession, calling, business, trade or business held or carried on by him at the time of publication. And this subsection is little used and there's no real authority on it, and on its face it merely adds a further requirement that the office is held at the time of publication and the loss is in respect of it. It's not mandating that the determination of likelihood of loss has to be as at the date of publication. I'm going to move on to more general submissions in opposition to the tendency test, insofar as I haven't already dealt with them. I think I've dealt with most of them already. It's the next section of my case on page 70 of the bundle, and it's section C of the case.
Section?
C of the case, on page 70 of the bundle, page 10 of the case. Because if you're going to say that the tendency test is the correct test, and you have to actually be clear in my respectful submission about how this is satisfied. Given that the Court of Appeal accepted, you had to go beyond the words and the circumstances of publication. But what other circumstances of publication apparently you're able to take into account only the identity and essential characteristics of the claimant, defendant, and publisher. Fundamental defect of the tendency test, as I think I've said, is that words don't cause financial loss in the abstract. It's the conduct which causes the loss. It's the publication of the words. There's a statement of Mr. Justice Briggs, as he was, paragraph 34 of my case, in a case called Fage and Chabani, which is on page 903. We don't need to go to it, but it says conduct is only calculated to cause damage within the meaning of section 3.1 if damage is in the ordinary course of events viewed objectively likely to be caused by the conduct of which complaint is made of. If you have a tendency test, you're inevitably going to give rise to arid and artificial debate about whether a fact obviously relevant to likely loss falls within the ambit of identity and essential characteristics. Looking at the facts of this case, at what point does Butler's decision never to do business with the respondent become part of his identity or essential characteristics? You've got the inconsistent findings of the Court of Appeal in relation to his status, who said that he was one of her customers. That's at paragraph 72, page 172, whereas the judge found, when the Butler words were spoken to him, he was not a client, would not be a client of the claimant by reason of the claimant's own other actions. I mean, it's not really necessary to categorise exactly who he is. The key point is that he's decided he never wants to do business with the claimant. That's the key fact.
Again, looking at your paragraph 36, do the Court of Appeal limit the circumstances to identity and essential characteristics? Do they illustrate it by reference to that?
Yes, they don't specifically limit it. They may or might. I mean, it's not clear. The structure of it, if we go to the judgment, because obviously if the tendency test was to be adopted, it's very important to specify exactly what satisfies it.
Yes, it's paragraph 56, I think, of the Court of Appeal's judgment that you're referring to.
Yes, 167 is the page. There's a sentence which is about 8 lines down. I think the context and circumstance of the statement must also be relevant, as they are whether determining whether a statement bears a meaning with a defamatory tendency. So that's a mandatory requirement to take into account the context and circumstances. It's not. I mean, it's true to say that they're potentially relevant as to whether a statement bears a meaning with a defamatory tendency, but they're not actually elements that are required to determine whether a statement is defamatory.
Well, suppose Mr. Butler hadn't been called to give evidence, there was no evidence about whether he wouldn't be interested in doing business, then the claimant could have relied, couldn't she, on Section 3?
Yes.
And she could have got some damages.
As it was a likely inference, potentially, yeah. I mean,
The real point is whether Section 3 still is going to carry you home when you've got positive evidence that there was no loss at all.
It's certainly permissible in a case of a publication to one person to draw an inference that it would have caused some loss. I mean, I can't specifically confirm that it would have applied in the situation of Butler if he didn't have the pre-existing desire not to do business with her, because I think you could say it would have been natural that Butler would have checked out whether the allegation was true if he wanted to do business with her. You see that point arising in other cases. But yes, as a general, of course, from the fact that he's a customer, that can form the ground of an inference.
Yes, I think we went to paragraph 56 because you've just been asking or referring us to your case in paragraphs 33 onwards. And in 37, you ask whether, at what point does Butler's decision never to do business with the respondent become part of his identity or essential characteristic?
Yes, but it was in response to a specific question from my Lord Hamlin about exactly what the Court of Appeal contemplated.
Yes, because what they went on to say after the passage you cited, it's a long-standing principle that the relevant context for that purpose may include the identities and essential characteristics. So it's not a limiting provision, it's telling you that the relevant context may include, but it doesn't say what else may be included.
It doesn't say that. And this concept of identity and essential characteristics doesn't appear at all in any of the defamation jurisprudence. No. And of course...
But they seem to be relying on the case of Bukowski. I don't know. I don't think it's in the bundle.
It is in the bundle, and I'll come on to it. But the important point is that this concept of
which is in the bundle.
Context is the only issue in defamation that it goes to is the meaning of the words. It's not a fundamental element of liability. If the defamatory imputation is clear, so there's no competing interpretations of it, it doesn't matter who it goes to. Go to one person who has no relationship with the claimant, and it's still actionable at common law. So it's a false comparison. And it's also false even to get into what happens in defamation, because as this court made clear in the show, it's a different interest that's protected, and the whole law proceeds on an artificial basis. And there's no need for this to be incorporated into an economic tort, such as malicious falsehood. So this precise extent of circumstances, context is unclear. If I had to, I'd say that on this case, it should include the three primary facts that I've referred to at the beginning. Why shouldn't it? But why even have such an inquiry? If you're going to take it from the date of publication, why not include all relevant facts in relation to the likelihood of loss, which has been the approach taken in the post-act cases that we will come on to. It's not a reliable indicator of loss, particularly when you're dealing with a single person. A reliable indicator is what particular knowledge does that person have, what's that person's existing estimation of the claimant. Paragraph 39, I record that it seems to be implicit in Court of Appeal's reasoning that calculated is to be equated with tendency, but we can see from the cases we went through, it's not understood in that way. It's just understood as a likelihood in all the circumstances. And I deal with Ratcliffe and White. Can I just go to Le Show? So I think it's worth just seeing what Lord Sumption had to say with characteristic clarity. It's at page 1115.
Could you give me the page number again?
It's 1115. And
that's 5, thank you.
Yeah, and judgment of law assumption starts at 1121. Paragraph 1, the tort of defamation is an ancient construct of the common law, has accumulated over centuries a number of formal rules with no analogue in other branches of the law. Most of them originated well before freedom of expression acquired the prominent place in our jurisprudence that it enjoys today. Its coherence has not been improved by attempts at statutory reform. And one of the artificial common law rules is the tendency test, which was addressed in this case because what the claimant was saying was that the effect of the serious harm test in Section 1 of the Defamation Act was simply to supercharge the tendency test, as opposed to an inquiry as to actual impact. And Lord Sumption rejected that submission, and it's helpful just to have a look at paragraphs 4 to 6. Where he contrasts defamation from torts where economic interest is the gist of the tort, and the law seeks to compensate for economic harm. It's on page 1123, and it's paragraphs 4 to 6.
Yeah.
I think they're just worth reading because it's the most
Right.
recent statement of this court on the harm element of defamation. And what the Court of Appeal have done effectively is to put in the tendency test from defamation into malicious falsehood. And when you go through it, you'll see Lord Sumption refers to it as being a number of more or less artificial rules. You can see the reference also to Sim and Stretch, 1936, and the tendency test that was the standard test in defamation at that time. I'm now going to move on to Bukowski and show that it doesn't have the statements of principle that appear to be attributed to it in the Court of Appeal's judgment. That's on page 813 of the authorities bundle. This was a case purely on interpreting the natural and ordinary meaning of the words. And the words were making a photograph. And it was used in an announcement, charging announcement by the CPS. And the rival interpretations were, 1, taking a photograph, or 2, making a copy of a photograph. And it was relevant in selecting the latter meaning that this was a being used in a technical sense in the formal charging announcement by the CPS. The passages cited in the Court of Appeal judgments are at 13 to 16 on possibly 13 to 17, doesn't make any difference, on page 816. And if you look at them, they're all about interpretation. Nothing about the identity and essential characteristics of the publishee. Court of Appeal also cited Gatley, chapter 3030, which is at page 1792. Chapter 3 is all about the interpretation of words.
Could I get the page again, sorry?
Well, it starts at 1793, but the particular paragraph that was cited by the Court of Appeal is on page 1795, under the heading Context and Circumstances of Publication. And you can see here, it's all about how you interpret words where there's an ambiguity and there's competing meanings, and it's mainly about the formality of the words. So you had Bukowski, where it's very formal, and then you had a recent case of this court in Stocker and Stocker, where it was a Facebook posting. And this court emphasised that you don't try and pass the meaning of something like this. It's just impressionistic. Nothing here at all about identity and essential characteristics of the publishees being relevant. It's all about the formality of the communication being relevant to the meaning, and that's only one aspect of the law of defamation, as I've said and will not repeat again. Totally unreal and artificial to exclude the three key primary facts to which I've referred, and there's no mandate in the authorities in the approach in defamation to do so. And of course, the statutory word is not tendency, it's calculated. There's another point in relation to Section 2, a case called Andre and Price, where Mr. Justice Tugendhat, I submit, correctly recognised that calculated to disparage in relation to slander had to take into account the likely effect of publication on the claimant's reputation.
The case again.
It's cited at 43.5. It's grounded on Article 10, so I was going to come to it. Sorry.
Paragraph
43.5 of the case on page 74.
43.
Yeah, page 74 of the bundle. It's just authority that you can. When you look at calculated to disparage, you don't just look at the inherent tendency of the words, even in defamation. You have to go beyond the words and look at their likely effect. And that's on the basis of Article 10. So I'll deal with that more specifically when I come on to Article 10, but just flag up.
But this isn't a debate, because I thought it was, but now don't think it is, about what calculated means, is it? It's a debate about what circumstances you take into account when you apply the statutory test. I mean, the words mean would naturally be expected to, or something like that. But the question is whether are you looking at that as some sort of abstract question divorced from the proven facts, and you say no. You say you look at all the facts that have been proved, and then you ask yourself, on those facts, would the words naturally be expected to, I would say, cause loss.
Yes. I mean, I'm
it's about what circumstances you bring into account. Do you abstract from the actual facts proved, or do you not? It's not about, I don't think, what calculated means. That's fairly straightforward.
Yeah. Well, it comes down to the outcome of this case, and of course I represent an individual defendant who's not going to be publishing to the world. It comes down to the admissibility of the three primary facts to which I referred at the beginning. But I deal with all this because of the Court of Appeal importing the defamation tendency test and justifying the approach taken by reference to how it works in defamation. And I'm showing it doesn't quite work in defamation in the way that is being suggested.
Will you say, well, in defamation you do look at the words in the abstract?
Yes.
Yes.
But that's not appropriate where it's a question of a tort of which the gist is financial loss.
Yes. One should not be quite as insouciant to allowing claims to proceed where there is no loss, which would be the inevitable effect of the tendency test. I don't think it's helpful to say how frequent that would be. When we look at the cases, you can see numerous examples that would succeed on a tendency test but failed on a proper causation test in relation to Section 3. But as a matter of principle and just to minimise unnecessary litigation, this court should not be allowing any litigation where there's an absent actual loss unless there's a very good reason for it and where there's an alternative that addresses any right of the claimant in a satisfactory manner. I'm now going to move on to the authorities on Section 3. I don't know whether it's helpful to start now or perhaps at 2 o'clock or 5 to 2. I think this clock is actually 3 minutes fast.
The clock is fast. It's 12:52.
Okay,
so if you commence.
Start. Yeah.
Could I raise one thing with you in the allocation of time in this case? On the sheet that we've been given, it suggests that you've got 6 hours and the respondent 3.
Yes, well, it has been the subject of communication with the court. I mean, the starting point is that the panel gave a 2-day estimate when permission to appeal was granted. Thereafter, the respondent has been quibbling with that, saying a day is sufficient, and the court has kept the 2-day estimate. And then I suggested an allocation which gave Mr. Bennett quite a lot more time than he's currently got, and he was insistent that he didn't need more than 3 hours. But I've said all along, I'm just happy to do whatever is helpful for the court. And if you want me to stop at any particular moment,
my point is simply, is the allocation that we have on our sheet the parties' agreed allocation?
yes.
Okay, then proceed.
Very odd, very odd. I've noticed that. I was wondering about it.
You will have seen that the Court of Appeal identified 2 conflicting interpretations. One was the historic test, one was the tendency test. It didn't really address the point in the respondent's notice of a forward-looking test taking into account all relevant circumstances in existence of the date of publication. My submission on the authorities were that they were consistent in taking into account all probative facts on the likelihood of loss. I accepted that some of them stated this on a forward-looking basis, but every time there was a relevant post-publication fact, it seems to be taken account in relation to Section 3. So the gravamen of my case on the authorities is a settled practice of applying standard tortious principles of causation to Section 3, thereby admitting facts extrinsic to the words and relatedly considering likelihood of loss in practice, not in the abstract. And this emerges clearly from the 3 most recent previous Court of Appeal decisions. I mean, as I say, when I go through this, I'm very conscious of the fact that we're in the Supreme Court for the first time on Section 3, and that you may not be assisted by this, but in my submission, it is relevant that we've, up until this decision in George and Cannell, we've had just constant our understanding, which you can see in the textbooks, that since the 1952 Act, it's been going for like 70 years, that you take into account all relevant facts. You admit competing causes. You look at the likelihood of loss in reality. So this would be a significant change, and therefore I submit it is helpful to look at the previous decisions, and they also provide good illustrations of why we need a proper test that takes into account extrinsic factors and how undesirable it would be to limit the inquiry, and impractical in certain cases to limit the inquiry. Given the, as I said right beforehand, a very wide breadth of the tort can cover almost any full statement, any type of loss. So, huge amount of scope for competing causes in play. Am I going with this clock or real time?
Well, I hasten to add, Mr. Price, that the allocation of time is unusual, and if you don't need 6 hours, you don't need to fill it.
I noted.
You appreciate that?
Yes, I take that on board.
Yes, right. If you want to adjourn at this moment, we will. The court will resume again at 2. Thank you.